Welcome everyone to the first YMP virtual webinars on current challenges and issues emerging from the lockdown. And I welcome you all on behalf of the YMP, obviously, but also Dr. Leka Shepherd and the London Shipping Law Centre. I'm very pleased that the seminar really, in some ways, had a great interest from our members and beyond. So today we have actually more people than we expected. And we have two speakers. We have Kevin Cooper from MFB Solicitors. I mean, most of you will know Kevin already. He has been he is one of our partners at MFB, and prior to that, he has been a partner for a very long time at Ince & Co. And before that, he worked in the Navy, and, you know, it would be it's quite a long, obviously a long experience solicitor, but he's also barristers, and he will talk to us today about what are the current challenges and issues emerging from the lockdown. This is particularly relevant for countries like Italy. I can see today that we have quite a few Italians, so obviously for Italy this would be extremely current. It will be a current issue for us, but the UK is just a couple of weeks behind, so obviously it's coming to the UK as well. Afterwards, I will basically introduce Manos, who is going to talk about Uncollected Cargo. Manos, some of you know Manos already. He's one of our committee members on behalf of TT Club. He has been working as a claim handler for a while at the club, but he previously worked in a law firm and with a shipping line in Genoa, and he's a Greek qualified, and obviously I would say that one of the main impressive things about Manos is that he's a multilingual person who speaks more than 8 languages, but most of you will know this already. I'll leave it to Kevin to speak now, and if anybody has any questions, we could deal with them if this is right for everyone at the end. Just for information purposes, the seminar and the webinar will be recorded, so a recording will be given to all participants, so it could be shared in your internal organizations as well. Kevin, down to you.
Thank you very much indeed, Francesca. And if everybody just bears with me for a moment whilst I share screen and find the presentation. Hopefully now everybody should see the presentation. And thank you very much indeed to Francesca, to YMP and the LSLC for giving me the opportunity to speak today. This will be a comparatively short talk, and the title is on the screen. Lockdown is being relaxed, but what will be the long-lasting effects of COVID-19. It's always nice to be part of the cool young gang that is the YMP, despite probably falling outside the Y element of MP, and also, I suppose some might say, the P bit as well. Just in terms of housekeeping, if you would be kind enough to make sure that you're muted throughout the presentations, that would be great. If you want to speak up, make a comment or raise a question, that's fine during the course of the presentations. Do remember to unmute yourselves, but there should be time for any questions at the end. You're welcome to keep your cameras on or turn them off, as they won't be disruptive. So what does this talk cover? Well, it's some predictions as to how, once the current lockdown is over, COVID-19 will have changed the environment in which we work. So what am I going to cover in this talk? Well, remember when you could just go out into the park and group hug strangers, as we can see in the picture in the slide, like in this photo? Well, hopefully those days will come again. But the world will no doubt have been changed by the COVID-19 experience, and indeed has already changed in the 4 areas that I intend to cover on the talk today. And those are some predictions as to the effects on the shipping industry, the effect on the insurance industry, particularly marine insurance, how contracts are likely to differ as a result of the experience that we've had over the past few months, and the likely effect on dispute resolution. So let's kick off with the story so far. And of course here, quite apart from the human toll of COVID-19, we're now increasingly, as it has largely come under control within Europe and the Far East, although I understand it is on the increase in certain other areas such as South America. Now we're all starting to focus on the economic impact. And indeed, I learned this morning that the UK is thought to have suffered a 20% contraction in its economy simply as a result of the last few months of COVID-19. To add to that, a report published by the World Trade Organization a couple of months ago predicted that world trade was likely to fall by up to about a third in the near future, and the International Monetary Fund recently predicted that the overall losses would exceed 7 trillion United States dollars. And to put that into context, that's a larger amount than the combined economies of Japan and Germany taken together. It's also recently been reported that in the first quarter of 2020, China suffered its first economic contraction since the Cultural Revolution in 1976. Now, this means that we're facing an economic downturn that will possibly put the Lehman Brothers crisis in 2008 in the shade. The US has recently been classified as being in recession, with more than 40 million United States citizens having filed for jobless benefits since the start of the pandemic. So the real unemployment rate in the US has risen to its highest level since the Great Depression of the 1930s. Though on the positive side, the stock capitalization of Zoom, the platform on which we're coming to you today, has soared to $42 billion, although perhaps it's a sign of the times that that's larger stock capitalization than all of the US airlines put together. So first of all, what's been happening and what do we expect to happen with shipping? Well, it's been predicted that the hardest hit shipping sector is likely to be car carriers due to the significantly decreased demand, about a 35% drop in demand for vehicle exports since the beginning of the crisis. But it's actually the passenger vessel industry that is suffering badly and that is likely to see perhaps the longer term effects. In the ferry sector, P&O and Stena Line have furloughed or redundant many of their employees. DFDS has put 12 of its 50 ferries into layup. Interferry, the trade body for the ferry companies, has said that business has halved across the industry and they're asking for state aid. The UK government, in fact, has provided some a £28.5 million rescue package. And while the ferries should recover in time, because people will still have to get from one place to another and there'll still be trade across short sea routes, the long-term outlook is rather more difficult, I fear, for the cruise companies. Now, of course, this is one of the sectors of shipping that's seen the most explosive growth over recent years with an aging demographic. But analysts have suggested that the cruise lines are unlikely to start to make a profit again until next year at the very earliest. Indeed, some are predicting that they won't actually start offering cruises properly again until 2021. And anybody who's followed this in the trade press will have seen that the various cruise companies are pushing back the dates of their first sailings on a month-by-month basis. Carnival Corporation, which is the largest company in the sector, has been raising emergency funds from banks and investors, including, it's reported, the Saudi Sovereign Wealth Fund. And the impact on the cruise industry was brought home to me by a cruise company client towards the beginning of the crisis, who mentioned to me that every news report that he saw on television had a picture of a cruise ship in the background. So they've become something of an emblem for the crisis in the public consciousness. Now, of course, you might remember that the Princess Diamond, the Diamond Princess, was one of the cruise ships that was first suffered a large number of infections, and at the time, if it had been a country, it would have had the second largest number of infections after China. And the problem is that the cruising is a retail industry. People can choose whether they want to take their holidays on a cruise ship, but they can also stay in a hotel, rent accommodation, or indeed take a staycation at home. And it's going to, I fear, take a long time for people to forget what's happened over the past few months. We've also, of course, seen reports of passengers bringing claims against the cruise companies, particularly at the beginning of the crisis, saying that once infections had been identified, the cruise companies should not have laid on further cruises involving those vessels. And indeed, there's been quite a bit in the press recently about resistance to those claims being brought, effectively a floodgates argument in the defences being raised in the US courts by the larger companies. And of course, the impact on the cruise industry will have a trickle-down effect on other industries as well. A lot of tourist destinations rely upon the volume of cruise passengers coming in to keep local shops, local attractions going, and there is not enough hotel accommodation, assuming it's possible to get flights there, of course, because the situation the travel industry and the airline industry is also very, very uncertain, perhaps even worse. So there's going to be a trickle-down effect amongst a lot of economies that are reliant upon cruise ship business. So not a good story. The box ship sector is expected to contract by up to 30%. There have been many cancelled sailings and many layups. One analyst has predicted that the peak has been reached, but I think that might be slightly over-optimistic. That said, freight rates have recently rallied, but that's been put down to proactive mitigation measures, so cost cutting by the main container lines. How far that can go with a drop in trade overall, and whether it's just a short-term solution is another matter, and many commentators are predicting some insolvencies. I read recently that in the bulk trade sector, in fact, it's not too bad at the moment. Capesizes, in fact, have seen some very good rates over the past few months, and indeed they've recently rallied again. Excuse me. One sector that has benefited to some extent from COVID-19 has been tankers, while people have taken a break from stockpiling toilet paper and pasta and masks, and started stockpiling oil during a period that it was very cheap, in fact, because of forward pricing. In fact, it was less worth than zero at one point. So that led to oil companies having to store more than they could actually cope with. We did see some some vessels being used for floating storage, but I think that's largely come to an end as a result of OPEC Plus deciding to scale down the degree of production. So I think oil tankers probably have had their moment of advantage from COVID-19. The LPG industry, I'm afraid, has had low rates throughout the crisis. On the people side, of course, not only have seafarers been infected, but precautions that have been taken in various countries have affected crew changeovers. That remains a very significant issue, although it's good to see that some countries, Hong Kong, for example, have started acting quite proactively to make sure that they can be used as crew changeover hubs. But throughout the crisis, the situation has led to crew being kept on board for much longer than they usually would be, and unfortunately there have been a number of suicides reported as well. And of course, reports on the effects of coronavirus on seafarers will exacerbate the concerns that were already there about recruiting crew, especially officers, into the industry in the future due to the perceived unattractiveness of the job. It's also, of course, been reported that shipbuilding and scrubber refits have been delayed. Meyer Turku, for example, the Finnish shipyard, has sacked some 450 of its people, expecting its main market, which is cruise ships, to contract by about a half over the coming years. We've recently seen the quietest month in bunker sales in the past 30 years. The sale and purchase market is very quiet, and the ship recycling industry has all but shut down, although I understand that it's started to open up in recent days and weeks. You may have heard reports that the Salvor Ardent is taking no more salvage contracts, so it's not clear how much of that can be attributed to COVID-19 and how much to the business situation prior to that. In the longer term, Rodolphe Sade of CMA CGM has suggested that this experience will change supply claims in the future, moving manufacturing much closer to the customer, which of course is consistent with the anti-globalization policies of certain politicians. In addition to the delay claims as a result of port congestion and quarantine, which I understand have so far not been as overwhelming for the clubs as some predicted. In fact, the prediction of the greatest P&I exposure is the passenger claims that I discussed earlier. But with many ships in layup, for example, 524 box ships are reported to have been laid up in mid-May, this is likely to result in hull fouling when and if they begin to trade again, leading to increased costs at a time when owners will actually be trying to make up some of the shortfall. Well, before I leave this topic, I've given you enough time to wonder about the picture on the slide. This allows me to tell you an interesting fact, or at least a fact that I found rather interesting when researching this topic for talks. COVID-19 has, of course, led to vessels being quarantined, and I've learned that the word quarantine derives from the practice in medieval Venice of making ships arriving from plague-infested ports wait at anchor for 40 days. So with apologies to those Italians on this webinar, 40 giorni, 40 days quarantine. The British obviously can't pronounce Italian very well, so they just turn it into something that vaguely resembles something English sounding. And indeed, if you look at this very early drone photo, you can see some vessels sitting out there 40 giorni just outside Venice. And a few words about insurance, particularly marine insurance. Of course, like shipping, the impact already has been and is likely in the future to be very significant. Last month, Lloyd's of London estimated a 203 billion United States dollar loss to the insurance industry as a result of COVID-19. And we do not yet know how long it will last, nor indeed what might follow. And this means that insurers such as the P&I clubs will need to keep on top of their risk management advisories to their members, ensuring that they have appropriate systems in place to minimize the risks to their crews and to cope with the effects of further periods of restraint on trade. And the picture on this slide is an example of the pooling of information between P&I clubs as the effects of COVID-19 in various ports, which has been administered by the international group. It's been suggested that when assessing risks going forward in relation to pandemics of the type that we've experienced, insurers will need to apply the latest modelling techniques to the various what-if scenarios so that they can price their cover and develop their plans based on the latest modelling and scenarios, not least because their regulators will likely come to expect that, and of course it will help to manage the solvency of insurers. I also recently read that there has been a suggestion that there should be some state support for insurers, effectively a company that's come to be known as Pandemic Re, in order to help the insurance industry to weather this unprecedented crisis. And this leads to another observation. At the outset of the crisis, there were a lot of webinars on the operational issues arising from COVID-19. Now, I personally am finding increasing invitations to webinars on how to manage insolvency. Now, this might cause a boom time for insolvency practitioners, but I'm afraid to say it will be bad for everyone else. Moving on to contracts. Now, recent months have caused many of us to refresh our memories on force majeure and infectious diseases clause. Now, I found it quite easy to find a picture about contagious diseases clause, not so for force majeure, but hopefully you'll be able to work out the very bad pun on the left-hand side of the slide. So looking at force majeure and infectious diseases clauses, well, the first appear in many of the contracts with which we deal, the latter less so. Now, I'm not going to go into any of the details. Many of you will have been talked to death on the subject, perhaps by me. But in view of the fact that COVID-19 may well be around for a long time, it would arguably be negligent going forward for people not to include one or both of this type of clause, addressing the allocation of risk between the contracting parties in the event of a situation such as the one that we've recently experienced. If you've got some sort of clause that deals with this kind of situation, there's more predictability in the contract, less scope for argument, and possibly litigation or arbitration. In brief, at least under English law, force majeure is purely contractual. And so the situations in which COVID-19 or anything that follows it do or do not trigger the force majeure provisions need to be carefully considered, as well as the implications. For example, does the clause trigger suspension of performance or termination of the entire contract? Now, as to infectious diseases clauses, after the Ebola outbreak in 2015, BIMCO prepared these clauses, one for time charter parties, one for voice charter parties, but they could be suitably amended for any contract that's being drawn up, with a view to responding to extreme outbreaks of diseases and not just everyday illnesses. And the clauses are very, very good ones, and one might expect them to have been adopted in the market. But so far as I can tell, amongst the printed form charter parties, only BIMCO Supply Time 2017 has one of these clauses included in the printed terms in part 2. Now, perhaps other BIMCO contracts will include them as they are periodically updated. But of course, as I said before, you could incorporate them or something similar into any of your contracts going forward. And as an aside, before I leave this topic, the law on seaworthiness may also develop as a result of the current situation. For example, where a number of the crew are infected or where the vessel is not in date with its certificates. Of course, ship owners need to be complying with the latest advice now and going forward. For example, fully briefing crews as to the risks and ensuring that they have adequate PPE. And then the last topic that I wanted to cover was just dispute resolution. Of course, it's easy to adjourn hearings, but that just delays the problem. Now, different jurisdictions have reacted differently. I'm currently, for example, involved in a case in the courts in Russia where the system seems to have pretty much shut down, although it's started getting back into operation in recent days. But in the UK, the judiciary was quite quick off the mark, and the Lord Chief Justice provided early guidance that more applications could be considered on paper or perhaps more accurately virtually. And in the London Business and Property Courts, which include the Commercial Admiralty Courts, which is where most shipping cases are heard, the tone was set when the Admiralty Judge, Mr. Justice Tier, responded robustly when the parties sought, or one of the parties sought an adjournment of a 2-week multi-jurisdictional enforcement trial. That went ahead. And courts and arbitrators are, in my experience, embracing video conference technology. Now, of course, there can be teething problems as a result of the rapid changes to which we've all been adapting over the past few months, but it's going well. I myself was involved in a 2-day Court of Appeal hearing some weeks ago. A few tips were picked up. One tip is to have a separate messaging system, such as WhatsApp, for the team to communicate and to stand in for the yellow post-it notes that tend to get posted up to the barrister at the front, where he or she normally promptly ignores them because they've got other things to think about. Apologies to any barristers listening at the moment. In some ways, for people other than those in the triangle of the judge, the barrister and the witness, it's actually a better experience. Rather than staring at the back of the barrister, other people, including the clients, get an opportunity to see the faces of people. Examination of witnesses can actually be better when you've got a close-up of them and you can see them sweating when they're asked a difficult question. The same is true of barristers. It's a good idea to be placed quite a way away from the camera if you are presenting the case, because similarly, judges may be able to detect when you're uncomfortable with the question that they've asked you. It also, to some extent, helps with reading the faces of the judges, but in my experience, that seldom really takes you anywhere. They're quite used to hiding what they're really thinking. Potential issues such as the public nature of hearings have also been addressed. It was already there in legislation. A little bit's been added in the UK's Coronavirus Act 2020, which focused more on criminal trials than civil ones because of the need for more careful process in criminal matters. And indeed, civil proceedings and arbitrations were quite used to taking evidence remotely by video link with witnesses who were overseas. In my case, members of the press were invited to take part in the Zoom call and did. And in another case, the one in the commercial court that I mentioned earlier, my understanding is that the virtual hearing was broadcast on television in the courtroom. Apparently there was nobody actually in the court to watch it, but it was broadcast on a television in the courtroom. For arbitration proceedings, the LMAA, the LCIA and the ICC are of course all operational, and indeed as about 80% of LMAA arbitrations have been conducted on paper, traditionally the change will not be that great. I also understand that a lengthy Lloyd's Open Forum arbitration will shortly be conducted by video conferencing. As to alternative dispute resolution, I think actually virtual hearings, or virtual mediations, I should say, are well suited to that form of dispute resolution. The various parties can have their own separate rooms, but can also have the plenary room where they all get together at the beginning and at the end, and sometimes halfway through. But the mediator can shuttle between individual private virtual rooms in the same way as he or she would do in a live mediation. So I suspect we may well find, particularly where the decision maker needs to travel, and it's good to have a decision maker in the room, we may well find more mediations being conducted by means of video conferencing in the future. Of course, these sorts of proceedings require electronic bundles, but the English court and arbitration systems were moving towards that anyway. And as I said, they've always been open to examination of witnesses by video. I suspect that COVID-19 has accelerated the process by some years, but we were going to get there anyway, and I don't think there's any turning back. As an aside, of course, it's beyond the scope of this talk to talk about the business and personal changes that COVID-19 will bring, but I suspect that we will find a lot more business contact, marketing being done virtually now, rather than by getting on a plane, assuming, of course, that the airline industry is anywhere near as widespread as it was before the crisis. And lastly, getting surveyors to incidents presents difficulties during a period when foreign travel is difficult, if not impossible. And in response, surveying companies in our industry have set up reciprocal arrangements with organisations in other countries, which I understand has been working well. Of course, it's more difficult for lawyers when they are involved, but we have been involved in remote casualty investigations, as I'm sure have others in our sector. And whilst it's no substitute in the appropriate case for face-to-face contact with the crew, and perhaps to assist the master in his dealings with the local authorities, the ability to screen share and to have a face-to-face conversation is not a bad second best. So that is all that I intended to say. There will be time for any questions at the end, and meanwhile I now hand over to Manos.
Today's topic is COVID-19 consequences from an uncollected cargo angle. What we will be covering, we will briefly speak about the current situation. We will speak about reasons for abandonment, the logistics operator's position. As you may know, at TT Club, we have considerable interests in some of the major logistics operators across the world. We will try to see how we can identify and prevent the risk, how we should react every time that there is an occurrence, and we will finish with some recommendations and observations. So, uncollected cargo, it's definitely not something new. It has long been a major challenge for all the stakeholders in the supply chain. And even though there has been a constant debate and attention and advice around the topic, it remains at the forefront of everyone's mind. Every year, the failure or the delay of the consignees to collect their cargoes results in storage, demurrage, detention, plug-in costs, which can very quickly spiral into tens of thousands of US dollars. Now we are in June 2020, and the COVID-19 is still raging unabated, affecting industries, businesses, and of course individuals. And as a result of the strict lockdowns and the restricted movements, we have seen markets freezing and stakeholders in the supply chain who are no longer in a position to use the goods that they have ordered and are in transit. In this unfortunate situation, we can see goods being locked up at transshipment and destination port terminals, freight forwarders' premises, warehousing, distribution centers. And I would have to admit that this is not something new. In every period of temporary economic decline, during which trade and industrial activity is reduced, we can see contracts rescinded and purchasers running away from unwanted cargo. But it's indisputable that the current situation with COVID-19 has affected the global industry in an unprecedented way. Moving on to the reasons of abandonment. So before the current crisis, there were various reasons, among which commercial disagreements between the seller and the purchaser, with the latter rejecting the consignment at the destination port. But the current lockdown, this extended lockdown, has negatively impacted the buyer and the consignee, who may no longer have a market for the goods, or their customer has ceased trading, or they simply cannot afford to pay for the goods. The delays in the shipments might mean that seasonal goods have missed their intended market. And as concerns perishable goods, they may have no more sufficient shelf life left. The warehouses are full or unable to open, and they no longer need the goods. And as far as ports are concerned, we have seen ports which, whilst they're open, they remain with reduced workforce, a factor which will definitely exacerbate cargo congestion. And this means that cargo that lies uncollected takes up space, and as a result, it reduces the capacity for incoming cargo and containers. We have identified some of the most frequent problematic shipment types, and we would say that these are personal effects, scrap and waste, metals, paper, used tires, used computer equipment, and of course illegal trades such as wildlife trafficking and counterfeit products. Of course, under the current situations, non-essential products for which there is no demand or little demand, as retail outlets are closed, those are also very likely to be rejected. So our experience has shown that the freight forwarder or the logistics operator will be the first party on whose lap the headache and the resultant cost will land, and they will definitely find themselves in a difficult position. Those are the first parties that the shipping lines will approach in order to claim for their losses, and this is either because the freight forwarder is mentioned as shipper or consignee on the ocean bill of lading, or because it has arranged the booking with the shipping line. Moreover, the freight forwarder may be the only entity that is traceable, and sometimes knowing that there is liability insurance behind, this may make it more enticing for shipping lines to bring a claim against these operators, because they will know that their chances of recovering something are increased. We always recommend to have a look at the definition of merchant on the ocean bill of lading, because sometimes this is broad and it includes shipper, consignee, receiver, freight forwarder, party that has arranged the booking, and sometimes the lines make sure that those parties are jointly and severally liable towards the shipping line for all the costs that might accrue. It's very important as well to establish the contractual position. Is the freight forwarder acting as agent only for the shipper, or is the party, because if this is the case, then he may be able to avoid liability. But if the freight forwarder is the party that contracted directly with a shipping line and has issued a house bill of lading on which they appear as shipper or consignee, then they are likely to have a contractual liability towards the shipping line for all the associated costs. it's important to be able to identify and prevent the risk. I know that it's difficult to completely avoid uncollected cargo cases, but on the other hand, by implementing sufficient management controls and by taking proactive steps, then you can definitely prevent it and tackle it. We would recommend to collate data with respect to risky uncollected cargo hotspots, non-reliable customers, commodities that are most likely to be abandoned. And once those problematic trade areas and routes have been identified, the relevant departments within the companies should be put on notice. Those departments would be the commercial and the operations departments, and they must be made aware so that they can take informed decisions regarding any bookings that present an elevated risk. Remember that consignees that have failed to collect their cargoes in a timely manner in the past, those are more likely to become repeated offenders, and bookings arriving from such customers should be carefully scrutinized and potentially rejected. If, notwithstanding the above, the bookings to those problematic trade areas are accepted, then it's worth establishing contact with local agents and correspondents and seek their advice as to how they can help with minimizing the risk. And for forwarders and operators, it's important to keep up to date with trends and developments. I have missed a D from the word N, I have just noticed it. And keeping in mind that certain socio-political circumstances, such as sanctions, may also influence the risk in certain jurisdictions. So quick action is of the essence. Once you're made aware of an uncollected cargo case or a similar occurrence, you have to react swiftly in order to minimize any potential exposure. Low-value commodities are risky because sometimes the associated costs, storage and demurrage costs, may exceed their commercial value, and as a result, the likelihood of having these cargoes abandoned is increased. Once an uncollected cargo case occurs, the shipper and the consignee must be contacted immediately, and they must be put on notice regarding the situation and given a deadline to collect the goods and settle any outstanding costs. Even though the shipper or the consignee might be reassuring that the case and the costs will be settled and the case will be resolved, we recommend to remain on full alert until the case is actually resolved. After the expiry of free time under the Bill of Lading, it's recommendable to send a formal notification explaining to the parties their rights and obligations under the contract of carriage or any other incorporated terms. And if, notwithstanding all these measures, nothing happens, then it's better to obtain clear instructions from the shipper as to how to proceed. For example, change the consignee's name, modify the destination of the shipment, arrange re-export. And lastly, it may be worth contacting the insurers immediately if there is cover for uncollected cargo. So if you know that you have liability insurance for this, you can contact your liability insurer at the earliest opportunity. Some further recommendations. Under the current situation, definitely, as it has been said, this is not business as usual, and goods must keep moving. The World Shipping Council advised that the world supply chains would break down if ports become congested, and it has urged governments to local and national governments to support policies that would ensure a fluid flow of cargo through container terminals. The Global Freight Forwarding Association, FIATA, in April 2020, called on carriers and terminals to exercise restraint in the application of extra charges. As it is mentioned here, shipping lines and terminals to exercise restraint in their demurrage and detention charges and practices taking into consideration this unprecedented time. And it's absolutely reasonable. There is no logic in enforcing a charge which is supposed to motivate the receiver of the cargo to collect the goods in a timely fashion if this is something that cannot be easily complied with. Under the current situation, shipping lines have started offering solutions, and they appear to be responding to their customers. They offer storage in transit, storage at origin, or holding cargo at transshipment hubs closer to markets where the products will be quicker to deliver once demand returns. In the UK, container hauliers are working together to offer shippers off-spot storage solutions for inbound sea freight. And these initiatives, I would say, they should set a good example for other players in the industry in order to help in the current situation. There is arguably a heightened importance in ensuring that standard terms and conditions are sufficiently incorporated into all new service or transport contracts. And we would advise to review your contractual conditions to ensure that your business is able to deliver the required level of performance in the current circumstances. It is prudent to seek open lines of communication with customers at an early stage, of course, in order to provide transparency with regard to delays and issues in transit and set realistic expectations. And of course, address timely any operational challenges that may be caused by a delayed delivery. Moving on, I would say that every occurrence must be assessed on its own merits, but options should be timely explored in order to minimize any accumulating costs. It may be expedient to arrange for the cargo to be transported and discharged into a warehouse where available until the mandated lockdown restrictions are lifted, or you can involve local expertise at the port of destination in order to assist with the onward movement or storage, destruction of the cargo, and of course any potential sale. And where liens are concerned, our recommendation is to obtain legal advice prior to exercising any liens, because you want to ensure that it is not possible for the rightful owner to bring a claim against you subsequently. And this is all I have to say. I know that this is a rather complicated topic, though the uncollected cargo cases are invariably complex and require expensive management time. However, if you implement the right measures, especially under the current situation, you may be able to avoid those. And that was my part. Thank you very much.
Thank you, Manos. So I think that if anyone has any questions, that would be the time to ask. And I can see that Kevin is also, waiting for questions. So I will leave it to you.
Hi, everybody. My name is Marina Comitardi. I'm a member of the legal department of Arcas Line, is a shipping container company. And actually, the matter whom Manos talked about is a matter of interest for us, because as a legal department, we handle claim and the overdues. With overdues, we refer to all the containers laid down at terminal and abandoned. What we faced at the beginning, of course, was our first worries was the force majeure that maybe some terminals could invoke, just to avoid that the shipping line would refuse to pay the storages. But from our experience, we noticed that nobody invoked the force majeure so far. So we basically handled all our overdues as always. But my point is, I have a question directly to Manos, because for his role in TT Club, is how terminal I mean, what is the trend for terminals to cooperate with the shipping lines to protect shipping lines' interest? I mean, in terms of storages, because of course we can seek our recovery for freight forwarders, against shippers or consigning, but all the recommendations you said actually imply some cost for the shipping line. So the aim is, okay, we don't want to pay any extra charge. We can cut totally our damages, but the storages will remain on the shipping line account. I mean, the storages charged by the terminals. So I was wondering, what is the trend of the terminals worldwide about the storages for the shipping lines?
Well, whilst I cannot speak about the terminals worldwide, I mean, I know that that's why bodies like the World Shipping Council or the or FIATA have mentioned that there should be a cooperation between lines and terminals when it comes to imposing storage charges. I am sure that under their contract, the terminals are pretty legitimate in enforcing storage charges upon the lines, but they have to understand that this situation is unprecedented, and they should cooperate and probably reduce those charges. It's absolutely up to negotiation. It's not uncommon to see goods being locked up in terminals right now, and this is not something that the lines or the freight forwarders or the cargo interests are liable for. And I believe that there must have been discussions until now between terminals and lines regarding this, but I'm not aware of any specific terminal that contributed to such.
Okay, and last point. You also mentioned that it is recommended to notify the liability insurer, but with our P&I, we have a very strict deadline to notify them. We have to notify them within 30 days. And 30 days is a very short period of time to us to understand, okay, it will be abandoned, or the consignee has just having some problems to collect the cargo. And so I think that also from the P&I side, they should change something, I mean, for this particular situation to elapse. I mean, the period of time for notification must be, longer. But I don't know if you face some similar issues in this month about this. If you have any similar situation about the liability insurers.
Well, as I said, it's prudent to timely notify your insurer once you're aware of any similar occurrence. I know that under club's wordings, there are certain time frames within which you have to notify your insurer. But if you cannot simply notify your insurer for the simple reason that you're not aware of the situation, or you're trying to resolve it, I don't think that you would risk having your claim rejected by your P&I club or your insurer just because you notified this after 30 days.
Yeah, I mean, I'm going to stop, I swear. But no, because our problem is that generally our P&I replies that, okay, this case will fall under FD&D, so we lose part of the cost covered and something like this. But any case, we will end our issues internally. Thanks for your time, and thanks for your replies, Manos. Thank you.
Thank you very much, Marina. So is there anyone else who perhaps wants to ask question to Kevin or Manos to balance it out? Who knows?
Sounds like we covered it, actually, and it's 6 o'clock, UK time anyway, on a Tuesday afternoon. So
we're actually on time. So
yes, very precise.
Well, thank you very much, everybody, for tuning in today. And if any further questions do occur to you, then please do let us know by email or by follow up. I understand that Gerard will be sending the slides round so that people will have them after the event.
And I think also the recording would be also available, so for everyone. So we'll circulate that as soon as it is available, but it should be hopefully in the course of this week.
And from my side, I would also like to thank Gerard, Francesca, Kevin, and all of you for participating tonight. And as I said, this is the first in a part of a series of events that will follow. Would they be webinars, seminars, or gatherings among the YMP members? I really don't know, but we will definitely keep you posted.
No, definitely. And also what we are definitely discussing, having some social events as well. So if you have any suggestions, by all means, I mean, Gerard is going to actually ask for suggestions and feedback. So that's very important to us. So if there is anything you think we should improve or it should be better, that obviously, because for us it's the first experience, we're all very excited to run seminars online, but obviously it's a different way of running events. So it's all very new and temperamental, I would say. So I thank you. I think we can perhaps leave people in peace to enjoy their evening and.
Exactly. Closing it now. Thank you once again, everybody, and thank you, Francesca, and the YMP team for putting it together. Bye bye.
Thank you very much, Kelly and Manos. Bye.
Bye bye.